Good morning to all of you. Welcome to Legal Matters by Sai Babu Subakara. Today is Muharram. We wish all our Muslim friends celebrate the festival. Right. Our topic for today is courtroom exchange. You can call it as obiter dicta also. It has no place in the records. But please remember, whatever is stated by, whatever is observed by, whatever is held by the Supreme Court, definitely it will become the law of the land. But here it is only obiter dicta, that is passing remark. Even it has got its own value. 2 days back, Honorable Justice Sanjay Kishan Kaul and another Justice Sudhantu Dhulia, while they were inquiring into a matter relating to the cancellation of bail. For what? For non-cooperation by the accused person with the investigation. At that time, Justice Sanjay Kishan Kaul, orally said that cooperation with the investigation doesn't mean that the accuser has to say yes to the police. This is basically, normally every time the police will say he is not cooperating if he doesn't give the proper replies. Sanjay Kishan sir, he said, does not mean that the accuser has to say yes. This is more important. Suppose if the prosecution says that the accused is not cooperating with the investigation, they have to provide evidence. Here the fundamental point is, what is cooperation with the investigation, what is non-cooperation. So, while granting bail in non-bailable offences, maybe under 438, maybe under 439, the court will say that the accused has to cooperate with the investigation. What cooperating means? Is it enough if he attends the court on the times mentioned by the investigating agency? If he appears before them, is it compliance or is it cooperation? Yes, it's one point of cooperation. Second point is, he has to respond to the questions. He has to give answers to the questions. He has to give the correct answers to the question posed by the investigating agency. Of course, there is a bar. Article 20, Clause 3 says doctrine of self-incrimination. No doubt they cannot put him in an embarrassing position, but for other things he has to answer properly. Right? So this is not being done. Of course, every time the state says that the accused is not cooperating with the investigation. In such a case, according to Honorable Justice Sanjay Kishan Kaul, there should be substantial evidence to that he has not cooperated. Right? Merely saying yes to the questions put by the investigating agency doesn't mean that he has cooperated. So please remember. So here in this case, the counsel argued that the accused has been non-cooperative with the ongoing investigation. The court asked for the demonstration of the incidents where he did not cooperate with the investigation, but counsel failed to provide the substantial evidence of non-cooperation. Therefore, the Honorable Court has given him, since the advocate has to take instructions from the party, the Honorable Court has posted the matter to 2 or 3 days later. So here, the important point is, please remember, cooperation with the investigation doesn't mean that the accused has to say yes to all the questions put by the police. He can defend himself. Of course, at the same time, he has to answer all the relevant point in the questions. If he doesn't answer, definitely they can say that he is not cooperative. But even then, the investigating agency, they have to give substantive evidence to show that or to say that he has not cooperated. Otherwise, court will not take it into consideration. Please remember, this is only a courtroom exchange, or this is only a passing remark, or this is only an observation, or this is only an obiter dicta. It doesn't file into, it doesn't go into the records of the Supreme Court. Okay, thank you.